against the defendant. That's set out in section 10 of the Proceeds of Crime Act of 2002. So the court looked back over a period of 6 years at all the property owned or that's come into the defendant's hands or that he's since transferred on. All of that will be assumed to be part of general criminal conduct and will be liable to confiscation proceedings. If the court decides on the balance of possibilities that a criminal lifestyle is not found, the court will then decide if the defendant has benefited from his or her particular criminal conduct, and this is just the conduct which constitutes the offence or offences for which the defendant has just been convicted, and any TICs that flow from that offence which the defendant has asked to be taken into consideration when being sentenced for the substantive offence. The court can look at just those offences, so it's over potentially a far shorter time frame, and look at the property that the defendant has acquired just when those offences were being committed, and decide if he has benefited in any way. If the court determines that the defendant has benefited from either his general criminal conduct or his particular criminal conduct, it must determine the recoverable amount, which is the amount equal to the defendant's benefit from the conduct concerned. And that is, as I say, the recoverable amount. So the court basically looks at everything that they've assumed has come into the defendant's hands over that period of time, either 6 years in the case of general criminal conduct or just in respect of the offences for which he's been convicted in respect of particular criminal conduct, and total up the benefit that he's accrued. However, if the defendant can show that the available amount is less than the benefit accrued, then the recoverable amount becomes the available amount, which may in turn be far more beneficial for the defendant. The available amount is the market value of all of his assets, less any secured liabilities on these assets. The defendant would have to have some form of proof of this. It's not the case that he just says that I don't have anything to do with that, I don't have anything to do with that particular property. He has to show that he didn't. But if he is able to show that, then it really is just the market value on the assets which he says he has, less any secured liabilities. The court must then make a confiscation order in either the recoverable amount or the available amount. If the court goes down the route of the available amount, then it must set out a statement of findings as to why it's using the available amount rather than the recoverable amount, because I say the available amount will usually be a whole lot less than the recoverable amount, and therefore something has to be on record as to how the court have come to that particular finding. So when it comes to paying the confiscation order, the defendant is allowed to pay out of what resources he has available. So it's not set out in the terms of property that the court have assumed that the defendant has. He can pay out of whatever he has available to him. The reality of the situation is that it is likely to be the properties that the court have identified that he has an interest in, because if there were another pot of money somewhere else, this would all have to have been declared. It would no doubt have already been looked into by the prosecution and would have formed part of the confiscation order. But if, for example, his father or mother are very rich, there's nothing to say that they can't lend him the money to pay off the confiscation order, give him the money. The amount due in respect of the confiscation order is payable on the making of the order. The defendant, however, can ask for this to be extended by 6 months. It used to be 12 months, but this has been reduced to 6 months. The defendant, though, has to show just cause, i.e. he has to give an explanation as to why he needs 6 months, an extra 6 months. The reality of the situation is, though, that most defendants can't just come by the money that the court are asking them to pay, and usually they are tied up in properties. These properties usually have to be sold, and obviously the conveyancing process takes some particular period of time, but usually the courts are quite amenable to the extension of 6 months. And it has to be said that a lot of cases which are overlooked in the magistrates' court with regard to the payment of the confiscation, they're extended by a lot more than 6 months. I have a client who owes £576,000 in hidden assets. He has a couple of properties. It's obviously taking some time to sell them, but as he comes back to the court do tend to extend him, provided they can see that progress is being made. They will drill you, though, as to what you're doing, how are you going about selling these properties, what stage is the sale at. They won't just take the word that it's happening and I should have the money in a couple of months' time. The sting in the tail is that interest is paid on the outstanding balance from when it was due to be paid. And the interest currently is at 8%, which is extremely high, 8% per year. So my client, who owes £576,000, his interest at the moment is £126 per day. He's paying back, because he's working, £800 per month, plus obviously trying to sell these 2 properties. But it doesn't even come close to covering the interest, much less the balance. And so what happens in those cases? The court, just like they do for non-payment of fines, have to set a default sentence. It's the court that sets the default sentence, and it's activated if the defendant does not pay the confiscation order within the required time. So my client, who owes £576,000, his default sentence is 66 months in custody. Obviously, he is selling these 2 properties, but the reality is he actually owes now more than £576,000 because of the interest. However, it's presently only the capital that the default sentence is served on, and not any interest owing. So he won't go to prison for longer than the 66 months. Obviously, again, the sting in the tail is, if the court get fed up with him and they're saying he's never going to pay off this money, they will activate the 66 months. He'll go and serve his custodial sentence. But when he gets out, obviously the £576,000 is still waiting for him to be paid. Probably the one comfort for him is that presently nobody can be asked to go back to serve a second default sentence for non-payment of the capital. Once it's been served, that's it. You can't go back again. And as I say, at the moment, there's nothing in place for sentences for the non-payment of the interest. So to end with, there's just some figures in respect of asset recovery. It obviously, since 2010, since this Act was introduced, has been fairly beneficial financially. So since 2010 to 2013-2014, £746 million of criminal assets have been seized over the 4 methods of seizing criminal assets, so not just confiscation, civil recovery, taxation, and asset recovery. Assets worth £2.5 billion have been frozen in that period, denying criminals access to these resources, and £93 million have been returned to the victims. So there you are, that's the end of the course. I hope you enjoyed it, and I hope it gave you a brief overview of confiscation orders.